This is a fascinating story because, one, it concerns South Carolina, and that sounds ominous usually. It also concerns South Carolina Supreme Court, which I don't know how much we know about the South Carolina Supreme Court, but that doesn't sound promising. And yet, they recently struck down the heart of South Carolina's voucher program. They said in a 3-2 decision recently that using taxpayer dollars to fund private religious schools violates the state constitution. Check this out. This is from like page whatever 5 of the lawsuit. Look at what they say right there in we hold portions of the act violate South Carolina's constitutional prohibition against the use of public funds for the direct benefit of private educational institutions, which is legalese for saying your voucher program is illegal. So let's talk about what happened in South Carolina. Okay. South Carolina has a version of something called a Blaine Amendment, Blaine. And basically, that's a reference to an amendment that was supposed to be in the US Constitution back in like 1875. It would have prohibited federal money from going to religious schools. It did not get into the Constitution for many reasons, but even though it didn't pass, 37 states have their own version of that law. I just showed you a version of it in Ohio. Public dollars cannot fund private religious schools, right? So South Carolina is one of these states that has a version of the Blaine Amendment. This is what it says in South Carolina's law. Look at number 4, section 4. Direct aid to religious or other private educational institutions prohibited. No money shall be paid from public funds, nor should the credit of the state or any be used for the direct benefit of any religious or other private educational institution. That's pretty plain and simple, right? Public money does not support private religious schools. So great, it's in the state constitution. That is a good thing, right? But in 2023, Republican lawmakers passed something that they called the Education Scholarship Trust Fund Act, which basically gave families up to $6,000 so they could send their kids to private schools or public schools outside their zoned districts, as long as the families met certain requirements. But ultimately, taxpayer dollars were funding private education. You could see where this is going. Now, Republicans tried to argue this is totally legal. The vouchers were not a direct benefit because they were giving money to the families and not the churches. They said, we're putting money in a trust. We're not giving it to the private religious institutions. And the court was like, yeah, we see what you're doing and we don't buy any of it. This is interesting. I want to show you one thing they said right here in the majority's decision. Check this out. Look at the very top line on your screen. After we clear away the window dressing, we can see the act funnels public funds to the direct benefit of private schools. This is what our Constitution forbids. And elsewhere in the same decision, check out what it says. Let me make sure I'm getting you to the right place. And where did it? Here we go. All right, look at this last paragraph. The dissent, remember, it was a 3-2 decision. The dissent claims our decision pulls the rug out from under the feet of the General Assembly and ultimately the feet of the students the law was designed to serve. Our duty is to serve the Constitution, the supreme policy of our land. As such, our obligation is not to allow a rug to cover up well-marked constitutional ground, no matter how inconvenient that ground may prove to be to otherwise arguably salutary policies. The entire concept behind the Constitution and the rule of law is that the end cannot justify the means. That is like a legal mic drop moment right there. There was a guy quoted in an article about this. His name is Patrick Kelly. He's the director of government affairs for the Palmetto State Teachers Association. Check out what he said, referring to what the Supreme Court there said. The court didn't say this, but basically they've made the argument that if it walks like a duck and it quacks like a duck, it's a duck. it's still public funds. And those public funds, if directed to a private school, are directly benefiting the private school. And the Constitution says you can't do that. The General Assembly cannot do that. So, yeah, like the Supreme Court of South Carolina shot that idea down. Not only is that the correct decision, it actually won't upend the lives of families who already use this year's vouchers because they're not being asked to return the money. And how many people use these vouchers? This is fascinating to me. This is from the South Carolina Daily Gazette. Look at the subtitle here. South Carolina law allowed up to 5,000 students to receive up to $6,000 each. But look at the headline now. What happened? Less than 3,000 students set to receive vouchers. Thousands of applications were denied. And it turns out those 3,000 students only got an average of $1,500 per kid. So it seems like South Carolina lawmakers set the cap so high, anyone could get the vouchers. Not a lot of people really use them. So that's good. That means the Supreme Court's decision won't actually impact that many families. No one is stopping them from attending those schools, by the way, if they want to. They just won't get a $1,500 gift for their schools. And the Supreme Court actually said, you know what, if you want to use it for transportation to public schools outside your area, you can absolutely use the voucher money for that. But you can't use it for a public school. I'm sorry, you can't use it for a private religious school. Now, you can pay for tutoring, you can pay for textbooks, but beyond that, you can't use it for tuition, right, at a private school. And if families want to keep sending their kids to the private school, they have the right to do that. They always have the right to do that, but then they got to figure out how to pay for it. It's not the taxpayer's job to do that. There's one other thing I really wanted to highlight in here. In that decision, in the Supreme Court's decision, they actually went through the history of why that Section 4 was in the Constitution. Why doesn't South Carolina allow public money to be used for private schools? And I found this fascinating. You know what they said? When they went through the history of it, they said that clause was added to the state's constitution in 1972. Why was it added in 1972? Because racists didn't want their kids attending an integrated public school, so they tried sending their kids to private school. And lawmakers are like, we don't want you to use taxpayer dollars to promote, we don't want you to like promote segregation with taxpayer dollars. So they passed this law that said, if there's public money, you don't get to use it to go to a private school. That's why. It was to stop like racists. So anyway, all of this decision, it is very good news for anyone who cares about public education. As I've said before, the arguments in favor of school choice include this idea that, you know, it's always giving parents the ability to choose the best education for their kids. And if that best education happens to be at a private or religious school, so be it. But the reality is that many students receiving these vouchers, they already would have attended the private school. They didn't need the money. And the public schools end up losing funding that they actually need. And that's really concerning since public schools by definition are for everybody, while private schools can reject students with special needs, students who have same-sex parents, students who may need additional help, etc. Like vouchers are nothing more than gifts for people who usually don't need the financial help and for private schools that are not popular enough to exist on their own. And yet vouchers across the country are getting there are billions of dollars, taxpayer dollars being used for vouchers across the country. And in some states, I just mentioned Ohio in a previous story, these programs are blowing a giant hole in the budget while simultaneously making public education worse. It's happening in Ohio, it's happening in Arizona. Like those decreased funds disproportionately affect schools in low-income neighborhoods. It affects students of color specifically, and that has a ripple effect throughout their communities too. And you know, these lawmakers, after making public schools worse, are going to use that to justify more money going to private schools. And instead of working to improve public schools, lawmakers in South Carolina try to make it worse. In fact, earlier this year, they proposed a bill to expand the voucher program to eliminate any income cap for families that want to take advantage of it and a cap for how many students could use it. They wanted to blow up their budget and let everyone use vouchers if they wanted it. And they offered up a bill in that same bill. They wanted to get rid of state audits for private schools getting any of this money. And they wanted to get rid of standardized tests that would have allowed people to directly compare the education kids were getting at a private school versus a public school. Basically, they wanted private schools to get a ton of money and have no transparency. And so, thank goodness, the Supreme Court has put a stop to that right now before everything got significantly worse. One thing I did find interesting is it's not entirely shocking because the South Carolina Supreme Court has done this before. In 2020, when South Carolina got a lot of COVID funds, check this out. This is from 2020. The South Carolina Supreme Court has ruled against Governor Henry McMaster, stopping him from using COVID relief money to fund private school scholarships. He tried to use $32 million of COVID relief money to give to students to go to private schools. And the Supreme Court's like, you can't use COVID money, public money, to send kids to private schools. That violates the same part of the Constitution. We're not allowing you to do that. And so they were right then. They are right now. Doesn't mean the fight is over. It is always possible for Republicans to pass a different law to circumvent the state constitution. They could also ask voters if they want to remove that part of the Constitution through a ballot initiative. But there's a reason they don't really want to put this in voters' hands, because voters usually don't like it when you say, do you want to help us destroy public schools? But they will try something, okay? Because there's nothing Republicans in South Carolina enjoy more than destroying public education. Look at this line from the Associated Press right here. Allowing parents to spend public money on private schools has been a 2-decade effort that ran through 3 governors, 4 House speakers, and 5 education superintendents in a state where Republicans have been consolidating and expanding their power. They have been trying to do this voucher thing for so long, and the Supreme Court just stopped them. And what did Henry McMaster say in response to that decision? Here he is. There's the date. You can see September 11th. It was just recently. We will request the court to expeditiously reconsider this decision. Like, he wants the court to do a backspace on their decision so that he can waste money on private schools. They're going to keep trying to do this. South Carolina voters could help put a stop to it by voting these people out of office as well. I know it's an uphill climb, but there you go. That's it for now. What questions we got for this story? Sounds like the real welfare queens are the religious private schools. Man, they just mooch. And if you can't do it by yourself, if you're a private school, religious school or otherwise, and you can't make it work, that's a sign that you shouldn't be in business. It's not that complicated.